Blended families have special estate planning issues. Now, by blended families, what I mean is when one person in the couple or both have children by a different person. So this is what I would call his kids, her kids, sometimes our kids, or some combination thereof. And it's very common. We have a lot of blended families that we work with, but we definitely recommend, if you're in a blended family, it's very important that we walk through some of those issues very carefully. So for example, we'll talk about stepkids. Some people are very close to their stepkids. I've heard families where it's almost like the step-parent has raised that child and really thinks of them as their own child. And they're very close, have a close relationship, they get along great. Other times, and they would want to provide for that stepchild. Other times, it's the opposite. They are not close at all. Sometimes there's a lot of animosity or hurt feelings, or they just plain don't like each other, or they would never want their assets to go to their stepchild. And of course, everything in between. So planning for stepchildren is not a given. So under California law, it's actually somewhat unclear about whether your stepchild would be automatically included or not. There's a lot of factors that go into that kind of a determination. So we never want to leave it to chance. The other thing about blended families is it's very easy to accidentally disinherit your children. So I'll give you an example, and it comes up a lot. Mom and dad had 2 children. They got divorced. Let's say dad remarried, and now he has his new wife, and maybe they have children together. And maybe they've been married a long time. And over the course of time, dad and new wife, new wife comes on title to the family home. Maybe dad refinances, and new wife comes on to the deed. And then when dad passes away, that house goes automatically to new wife. When she passes away, most likely then it will go to her kids. So that's one way that I see with blended families, where whoever passes away first, typically everything might go to their new spouse, and if there's no planning in place, then the kids from the first marriage or first relationship end up becoming disinherited. And most of the time that's not what the person thought would happen, and they maybe don't want that to happen at all, but it is something that would happen if there's no planning in place. The other thing about blended families is we have to make sure that we don't have any surprises. And by that I mean sometimes people want their new spouse to have that management and control if they pass away, and other times they want to leave that management and control with their children from maybe a former relationship. So deciding who would be in charge, who would be that successor trustee if there's an incapacity or a death, is very important to think about carefully in a blended family. The other thing about blended families is sometimes there's separately titled assets in one person's name. Sometimes there's separate property, community property. Sometimes there's jointly titled assets. And depending on the title of the assets is going to make a big difference in where those assets would go if someone passes away. So with a blended family, that's particularly important. Sometimes a spouse would want everything to go to their new spouse. But other times they want to make sure that they provide for both their new spouse and for their kids from prior marriage. So I'll give you an example that I think makes it really clear. I had a gentleman come in. He had 2 adult children that he loved very much from his first marriage, and he had a new wife who he loved very much. And he had a large 401k. And that was his biggest asset. He wanted to make sure that if something happened to him, that he was providing for his new wife. So if he listed his wife as the beneficiary on that 401k, he would be providing for her. When she passed away, she would be able to leave it to her kids, who he didn't really know. He wanted to make sure that he provided for his new wife, but when she passed away, he wanted to make sure that the rest of those 401k funds would go back to his kids. So that wouldn't happen automatically. So if he just writes his new wife on the beneficiary form, then the result that he didn't want is what would happen. So after sitting down and having a conversation, we could give him a solution so that he could both provide for his new wife and make sure that after she passed away, his assets would then return to his adult children.